Progressive Legal Exercise 16. Ready? Start. The revenue being aggrieved by the decision of the board, filed tax revision petition before the High Court under section 86 within bracket 2 of the Act. Stop. The High Court dismissed the petition filed by the revenue and upheld the decision of the board by holding that the respondent unit is a prestigious unit and therefore entitled to 75% tax exemptions under the scheme. Stop. Aggrieved by the order so passed by the High Court, the revenue is before us in this appeal. Stop. We have heard learned counsel for the parties to the case and peruse the documents on record as well as the order passed by the authorities and the High Court respectively. Stop. The learned senior counsel appearing for the appellant submits that the case placed by the respondent unit right from the beginning of filing the application before the state level screening committee was that the new unit had made an investigation of more than rupees 500 crores by way of fixed capital assets and therefore they should be placed under the category of prestigious unit and accordingly be granted eligibility certificate to claim 75% of exemption from tax for the maximum time limit provided under the scheme. Stop. In aid of this submission, the learned senior counsel would draw our attention to the application and the accompanying affidavit filed by the respondent before the state level screening committee. Stop. He would further contend that the respondent unit before all the authorities below, including the High Court, had adopted the stand that the fixed capital investment, excluding investment made before 5th March, 1997, was more than rupees 530 crores, and therefore the respondent unit is a prestigious unit entitled to an exemption of 75% of total tax liability. Stop. It is further contended that the respondent new unit being new cement unit and further being large scale unit, though he can avail the benefit of the incentive scheme under section 1E of Annexure C, which provides for exemption up to 25% of total liabilities, it cannot avail the benefit of exemption at the rate of 75% under item 4 as prestigious unit. Stop. He would further submitted that benefit to cement industry is confined to the extent envisaged under the item 1E of Annexure C, as the said item is a specific provision relating to the cement industry. Stop. Alternatively, it is contended that the respondent unit being new cement unit, it may fall under new very prestigious unit, however, item 5 of Annexure C speaks of the new very prestigious units other than cement units except those located in sub-plan area, respondent unit may not be entitled to avail the benefit of the scheme. Stop. Contra, learned counsel, would justify the reasoning and the conclusion reached by the High Court while rejecting the revenues revision petition and thereby confirming the view expressed by the board. Stop. He would, comma, inter alia, comma, submit that item 1e is only an exception to the general rule envisaged in item 1 and not an exception to other items in the annexure C, that is item 2 to 7, as it is not intended to govern the entire field of exemptions made available to the cement industry so far as to deny the benefits to a unit even if it falls under another item envisaging better incentives. Stop. He would further submit that since new cement unit is specifically excluded from application of item 1 and item 2 and item 5 but not item 4 and 7, comma, it falls that the intention behind such expression exclusion is such that but for the said exclusion, comma, cement industries would be included in the said entries. Stop. He would strenuously submit that since the tax exemption clauses are made with a beneficent object, that is to encourage investment in specified rural oblique semi-urban areas, comma, their construction must be liberal such as to confer the most beneficial meaning to the provisions. Stop. The facts which are not in dispute are that the respondent SSC established a new cement unit within Panchayat Samiti, comma, and commenced commercial production sometime in the year 1997. Stop. It engaged itself in the manufacture of cement. Stop. The total capital investment in the new industrial unit claimed by the company was rupees 500 crores. Stop. The company had applied for grant of eligibility certificate for exemption from payment of central sales tax and Rajasthan sales tax before the state level screening committee, comma, Jaipur, comma, under the scheme. Stop. However, comma, the screening committee accepted only rupees 55.32 crores as FCI eligible for availing the benefits under the schemes. Stop. On the aforesaid basis, the state level screening committee certified that the company is entitled to avail exemption of tax. Stop.